There is a sentence sitting inside a Manhattan court filing from October 2025 that is going to be quoted in entertainment law lectures for the next 20 years, and the most catastrophic part of it is that Drake's own attorneys are the ones who put it there. That sentence, buried on a page nobody in the music press bothered to open, is the single most devastating self-inflicted wound any major hip-hop artist has ever suffered inside a courtroom. And it happened while everyone in the culture was busy laughing at the diss track. They were laughing at the wrong page. They were reading the wrong headline. They were watching the wrong document. And while the memes were still cooking and the timelines were still dunking on Aubrey Graham for losing a federal case against his own label, Kendrick Lamar's legal team was quietly cataloging what may end up being the most valuable piece of paper in modern music litigation history. A piece of paper that Drake's own lawyers, in their attempt to win a defamation case against Universal Music Group, personally drafted, filed, stamped, and deposited directly into the public record of a rivalry that has now escalated from a rap battle into a full corporate warfare event with implications that stretch far beyond two artists and one diss track. Everything you have been watching about this situation has been framed around the wrong question. The culture has been asking who won the rap battle. The real question, the one that actually determines who controls the next decade of hip-hop business, is who won the paperwork. And the answer to that question is not close. It is not debatable. It is not a matter of opinion. The man who released Not Like Us did not have to file a single motion to win the legal war. He did not have to say a word in court. He did not have to hire a single expert witness. Drake's lawyers did the work for him, and they did it on the record under the standard of a filed pleading in a document that now sits on the federal docket for the rest of legal history. The deal that was signed when Drake re-upped with Universal Music Group for a reported $400 million, and the filing that was submitted to a Manhattan federal court in January 2025 are not two separate stories. They are the same story. And when we get to the contract structure breakdown, and I promise you we are getting there, you are going to understand why everything Drake has done for the last 2 years was never actually about protecting his reputation, and was always about a renegotiation that went sideways in a room nobody was supposed to know about. The personal stakes here are existential for one artist. The cultural stakes are about what it means when a rap beef stops being a rap beef and becomes a structural leverage transfer. And the systemic stakes, the ones nobody is talking about, are about who controls the distribution architecture of the entire music industry for the next generation. Stay with me, because the paperwork is where the real war was always being fought. Drop your thoughts in the comments, hit like, and subscribe. Let's get into it. Now, let me set the table properly, because if you do not understand the architecture of what was built before the filing, you cannot understand the devastation of what the filing actually did. Here's the situation as it stands. Drake, whose full name is Aubrey Drake Graham, has been signed to Republic Records, a subsidiary of Universal Music Group, for over 16 years. He re-signed with UMG in a deal that was reportedly worth upwards of $400 million. Not just a record deal, but what industry insiders described as a LeBron-sized, comprehensive agreement covering recorded music, publishing, touring, and merchandise. That deal, according to Drake's own complaint filed in federal court, was up for renegotiation in 2025. Keep that date in your head, because it is the skeleton key that unlocks this entire story. Kendrick Lamar, whose full name is Kendrick Lamar Duckworth, has been operating under a completely different business model. In 2020, Kendrick and his longtime creative partner Dave Free launched PG Lang, described as a multilingual, multi-service company specializing in music and visual media production. Since its founding, PG Lang has won 6 Cannes Lions Awards, expanded into streaming, apparel, film, and beverage categories through a carefully sequenced trademark architecture, and in July 2025 launched Project 3 Agency, a full-service global creative firm operating under the PG Lang umbrella, offering content creation, brand design, strategy, event planning, and production services across fashion, sports, art, and entertainment. That is not a rap company. That is a media conglomerate being built in real time by a man who spent
outdrawn by its own halftime show. And the song that closed that halftime show was not 18 months letting his opponent humiliate himself in federal court. Now, here is where the timeline gets critical. On May 4, 2024, Kendrick Lamar released Not Like Us, the culminating diss track in what Judge Jeanette Vargas would later describe as perhaps the most infamous rap battle in the genre's history. Over 16 days, Drake and Kendrick released 8 diss tracks with increasingly inflammatory rhetoric, loaded accusations, and violent imagery. Kendrick fired Like That, Euphoria, 16 in LA, Meet the Grams, and Not Like Us. Drake responded with Push-Ups, Tailor-Made Freestyle, which featured an AI-generated Tupac voice, Family Matters, and The Heart Part 6. Not Like Us was the nuclear option. It debuted at #1 on the Billboard Hot 100. It held that position for multiple weeks and accumulated over 1.8 billion streams on Spotify alone. Numbers that are not just impressive for a diss track, numbers that are historic for any piece of recorded music in the streaming era. Let that sink in for a second. A diss track, a song specifically designed to humiliate another human being, became one of the most commercially successful singles of the decade. That is not a rap beef outcome. That is a cultural realignment event. And the man who recorded it didn't need to do a single interview to promote it. He didn't need to sit down with Complex or do a Hot Ones episode or drop a behind-the-scenes documentary. The song was the promotion. The song was the interview. The song was the entire media campaign, and it worked so effectively that the traditional promotional infrastructure of the music industry looked obsolete by comparison. I mean, does everybody understand how crazy this actually is? We are talking about a diss track that outperformed virtually every conventional single released in 2024, and it did so without a single traditional media appearance from the artist. That's not a flex. That is a system failure for everyone who has been relying on the old model. The second piece of surface evidence is the Grammy sweep, and this one matters in a way that goes beyond trophy counts. In February 2025, Not Like Us won 5 Grammy Awards: Record of the Year, Song of the Year, Best Rap Song, Best Rap Performance, and Best Music Video. The Recording Academy, an institution that has historically been cautious about rewarding diss tracks, controversy, or anything that smells like beef, gave Kendrick Lamar 5 of the most prestigious awards in music for a song that calls another artist a certified pedophile. Let me say that again so it really lands. The most conservative, historically risk-averse voting body in the music industry looked at a diss track that explicitly accuses a peer of being a sexual predator and said, yes, this is the best song of the year. This is the record of the year. This is the best rap song. This is the best rap performance. And this is the best music video. 5 for 5, a clean sweep. The Grammys didn't just validate the song, they canonized it. They took a diss track and elevated it to the status of cultural landmark, and in doing so, they permanently cemented every lyric in that song into the institutional record of American music. That matters because when the most prestigious award body in the industry validates a diss track at this level, it becomes virtually impossible for the target of that diss track to reframe the narrative later. The Grammys aren't a blog, they aren't a podcast, they aren't a Twitter account that can delete a post. They are a permanent institutional endorsement, and that endorsement now sits alongside the 1.8 billion streams and the #1 Billboard position as an immovable fact of music history. Drake cannot undo the Grammys. He cannot appeal the Grammys. He cannot file a motion to dismiss the Grammys. They happened, they are permanent, and they're the second layer of the surface evidence that makes his legal strategy look even more desperate in retrospect. The third piece of surface evidence is the Super Bowl LIX halftime show on February 9, 2025, and this is where the numbers get almost incomprehensible. Kendrick Lamar performed Not Like Us live on the Super Bowl halftime stage in front of 133.5 million viewers. That's not a typo. 133.5 million people watched Kendrick Lamar diss Drake on the most-watched television broadcast in American sports. The halftime show drew a larger audience than the Super Bowl game itself. Let me put that in perspective for you. More people watched Kendrick diss Drake than watched the actual football game that the halftime show was inserted into. The Super Bowl, an event that is already the most watched broadcast in American television every single year.
Feel-good pop anthem. It was not a career-spanning medley. It was a diss track, a targeted, specific, by-name attack on another artist, performed on the biggest stage in American entertainment in front of an audience that included children, grandparents, people who have never listened to hip-hop in their lives, and people who had no idea that a rap battle was even happening. Drake's own legal team would later argue in their appellate brief that millions of Super Bowl viewers had never before heard the recording or any of the songs that preceded it, meaning they heard the pedophile accusation with zero context about the rap battle. And Kendrick performed it anyway. He looked into a camera that was broadcasting to 133.5 million people and said the words. He did not soften them. He did not hint at them. He did not substitute a euphemism. He said the actual words on the actual stage to the actual largest audience in Super Bowl halftime history. That is not a performance. That is a power demonstration. And it happened while Drake was preparing a lawsuit that would, ironically, make all of this even more permanent than it already was. The fourth piece of surface evidence is the lawsuit itself, filed in January 2025 in the Southern District of New York. Drake did not sue Kendrick Lamar. Let me repeat that, because it is the most strategically revealing decision in this entire saga. Drake did not sue the man who wrote the lyrics. He did not sue the man who performed the lyrics. He did not sue the man who won 5 Grammys for the lyrics. He sued Universal Music Group, his own label, the label he has been signed to for over 16 years, the label he reportedly re-signed with for a deal worth upwards of $400 million. And in that lawsuit, Drake's legal team made a specific, deliberate choice about how to frame the alleged harm. They characterized the injury as reputational damage flowing directly from what they called a coordinated promotional campaign that UMG deployed behind Not Like Us. They accused UMG of intentionally publishing and promoting the song while knowing the lyrics were false and defamatory. They alleged that UMG waged an unrelenting campaign to spread the recording as widely as possible. They even claimed UMG colluded with Spotify to artificially boost the song's streaming numbers. On the surface, this looked like a coherent legal strategy. It gave the press a headline, it gave the public a narrative. It aligned with Drake's own posting history at the time. But what it actually did was something that no legal analyst in the entertainment press bothered to explain, and it is the thing that changes everything about how this story ends. Because when you file a defamation case, you are not just asking a judge for damages. You are creating a permanent evidentiary trail that lives inside the public court record forever. Every claim you make in that filing becomes a formal admission by your own counsel. Every characterization you deploy becomes a citable fact. And Drake's legal team, in trying to protect his reputation from the fallout of Not Like Us, left exactly the wrong sentence on exactly the wrong page of exactly the wrong filing at exactly the wrong moment in the biggest legal chess match hip-hop has ever seen. And the next section of this video is where I explain why that sentence is going to reshape the balance of power inside the biggest label on the planet for the next decade, and why the man who benefits from it has not said a single word about it publicly. And oh, do I have more for you. Because if you think the surface evidence is where this story peaks, you are not ready for what is sitting underneath it.
The stands for a certain artist are really not going to like what comes next, because what I'm about to walk you through is the layer where this stops being about a rap beef and starts being about the largest structural leverage transfer in modern label politics. I am talking about the insider reactions, the corporate chess moves that have been happening behind closed doors, and the pattern that connects the lawsuit to a business architecture that has been under construction for years. And I'm going to start with something that happened in the courtroom that almost nobody caught. A moment where Universal Music Group's own attorneys said something that, when you connect it to the P.G. Lang trademark filings, changes the entire picture. So stay right there, because the next piece is the one that makes the previous evidence look like the warm-up act. Let us move to the cultural evidence, because this is where the story starts feeling like you're getting information that basic fans do not have access to. The first piece of cultural evidence is the reaction from Universal Music Group itself, and it is more revealing than anything UMG probably intended. When UMG filed their motion to dismiss Drake's lawsuit in May 2025, their legal team characterized Drake's allegations as, and I'm quoting here, wild conspiracies. They described the entire lawsuit as Drake's attempt to save face for his unsuccessful rap battle with Lamar. But here's the sentence that matters. UMG's attorneys wrote that Drake intentionally and successfully used UMG to distribute his music and poetry to engage in conventionally outrageous back-and-forth rap battles to express his feelings about other artists. Read that sentence one more time. UMG, on the record in a federal court filing, acknowledged that Drake used the distribute infrastructure to attack Kendrick Lamar when it suited him, releasing Push-Ups, Tailor-Made Freestyle, Family Matters, and The Heart Part 6 through the same UMG distribution pipeline that he later sued them for using on Kendrick's behalf. That is not a defense, that's a grenade. UMG just told the court, on the record, that Drake was perfectly happy to use the label's coordinated promotional infrastructure to distribute his own diss tracks, and only decided that the infrastructure was illegal when the same machinery was used against him. Does Drake realize how absurd this actually looks? He used the pipes to attack, and then sued the pipes when the pipes were used to attack back. That is not a legal strategy, that's a toddler's understanding of fairness, and UMG's attorneys made sure it was preserved in the federal record. The second piece of cultural evidence is what Judge Jeanette Vargas wrote in her October 9, 2025 dismissal, and this is where the cultural shift becomes undeniable. Judge Vargas noted that the case arises from perhaps the most infamous rap battle in the genre's history, a vitriolic war of words between Drake and Kendrick Lamar. She wrote that Not Like Us is replete with profanity, trash-talking, threats of violence, and figurative and hyperbolic language, all of which are indicia of opinion. She concluded that a rap diss track would not create more of an expectation in the average listener that the lyrics state sober facts instead of opinion. And then she delivered the line that is going to follow Drake for the rest of his career. Not Like Us dealt the metaphorical killing blow. A federal judge, not a blogger, not a podcast host, not a Twitter personality, a federal judge sitting on the Southern District of New York used the phrase, the metaphorical killing blow, to describe what Kendrick Lamar did to Drake's reputation. That is not a legal ruling, that is a cultural verdict, delivered from the bench, in writing, on the permanent record of the United States federal court system. And when the culture reads that a federal judge called the song a killing blow, the culture does not need any more analysis. The culture has its answer. The court of law and the court of public opinion delivered the same verdict on the same day, and both verdicts are permanent.
The third piece of cultural evidence is the pattern of Kendrick Lamar's public silence versus Drake's public activity throughout this entire legal saga, and this is where the cultural shift becomes a philosophical one. Since the dismissal in October 2025, Kendrick Lamar has been almost entirely quiet on the topic of Drake. He has not posted about the lawsuit, he has not posted about the dismissal, he has not posted about the appeal. He released GNX in late 2024 with tracks that the culture read as reflections on the feud. He dropped Watch the Party Die in September 2024. He performed at the Super Bowl. He won 5 Grammys.
And then he went quiet, filed trademarks, launched Project 3 agency, and let his legal team observe. Drake, by contrast, has been in constant public motion. He released Fighting Irish Freestyle in January 2025. He dropped Gimme a Hug in February 2025 on his collaborative album with Party Next Door. He has been posting, touring, performing at the Wireless Festival in London in July 2025, and maintaining a relentless public presence. And here is the cultural significance of that contrast. When Drake fires, he fires publicly. When Kendrick fires, you do not even know he pulled the trigger until the paperwork surfaces 6 months later and somebody who reads dockets for a living notices what was actually done. The culture is watching two completely different approaches to conflict, and the culture is starting to understand, slowly, that one of these approaches is building an empire and the other is defending a shrinking territory. One person is playing chess, the other is playing checkers on the same board and wondering why nobody is impressed by his king jumps. Now, I want to be fair here for a second, because I think the counterargument deserves to be addressed. Drake's team, in their appeal filed on January 21, 2026, a 117-page appellate brief submitted to the Second Circuit Court of Appeals, made a specific argument that is worth taking seriously. They argued that Judge Vargas created a categorical rule that rap diss tracks can never be actionable. They argued that millions of people understood the recording and image to convey factual information, causing countless individuals around the globe to believe that Drake was a pedophile. They pointed out that Not Like Us was performed at the Democratic National Convention, at the Grammy Awards, and at the Super Bowl, massive audiences who had no context about the rap battle. They noted that the next most popular song in the feud, Euphoria, had just 4.1% of the streams and views achieved by Not Like Us, arguing that the song broke through the noise and achieved a cultural ubiquity that transcended the rap battle context. That is a genuine legal argument, and it is not a frivolous one. There is a real question about what happens when a diss track escapes the context of a rap battle and reaches an audience that has no framework for understanding it as hyperbole. I will give Drake's team that, but here is why that argument, even if it has legal merit, does not change the structural reality of what happened. Even if the Second Circuit overturns the dismissal and sends the case back for trial, the admissions in the original filing do not disappear. The evidentiary trail does not evaporate. The characterizations that Drake's attorneys made about UMG's promotional infrastructure do not get sealed or redacted because an appellate court ruled differently on the opinion question. The filing exists, it is permanent, and the leverage it created for parties outside of this specific lawsuit is already in play. The dismissal with prejudice was a devastating outcome for Drake, but even a reversal on appeal would not undo the structural damage that the original filing already caused. That is the piece that Drake's camp is not talking about publicly, because I do not believe they can talk about it publicly. And this is the moment where we need to shift gears entirely, because what is coming next is not about the culture, it is about the system. Now we are entering the part of this video that separates this channel from every reaction channel and every commentary channel covering this story, because we are about to leave the realm of rap beef entirely and enter the realm of corporate warfare, structural leverage, and the business architecture that determines who actually controls the music industry for the next decade. If you have been treating the Drake versus Kendrick situation as a rap beef, you have been watching the wrong movie. This has not been a rap beef for a very long time. This is a full-scale corporate restructuring event playing out in slow motion, and the songs are just the marketing wrap around the actual restructuring. The songs are the trailer, the film is the film, and the filings are going one way. So let me build this across 3 separate systemic angles, because each one of them is a layer of the same conclusion, and when you stack them together, the picture is undeniable. The first systemic angle is the evidentiary trail problem, and this is the one that nobody in the entertainment press has explained properly because nobody in the entertainment press reads court filings. When Drake's legal team drafted the original defamation action against Universal Music Group, they made a very specific strategic decision about how to frame the alleged harm. They chose to characterize the injury as a reputational damage flowing directly from what they called the coordinated promotional infrastructure
that UMG deployed behind Not Like Us. They used language describing a campaign to manipulate and saturate streaming services and airwaves. They characterized UMG's actions as an unrelenting campaign to spread the recording as widely as possible. On the surface, that framing looked airtight. It aligned with the public narrative. It gave the attorneys a clean, media-friendly through line to argue in front of a judge. What they were actually building, though, was a monument, a permanent, court-stamped, publicly accessible monument to a set of admissions that Kendrick Lamar's legal team couldn't have manufactured on their own if they had tried for a decade. Because here's the thing about defamation filings that nobody explains. When you file a defamation case, every claim you make becomes a formal admission by your own counsel. Every characterization you deploy becomes a citable fact. Every framing you use becomes a foundational element that any opposing party in any future related dispute can point to and say, your own attorney said this on the record, and you can't take it back. That trail does not disappear when the case is dismissed. It doesn't vanish when the news cycle moves on. It sits there on the docket for the rest of legal history, waiting for the right party with the right agenda to walk in and lift it off the shelf. And Drake's legal team, in trying to protect his reputation from the fallout of Not Like Us, formally acknowledged in court that Universal Music Group runs coordinated corporate promotional campaigns on behalf of specific artists using specific infrastructure. That acknowledgement is now sitting inside the public record. It is discoverable, it is citable, it is admissible. And the party that benefits the most from that acknowledgement is not Drake, and it is not Universal. It is the third party sitting quietly in a Los Angeles office, running a fully vertically integrated media company called PG Lang, watching this entire situation unfold with the calm of a legal team that has been 3 moves ahead for a year and a half. That third party is Kendrick Lamar, and the leverage he just inherited is the kind of leverage that major labels lose their leadership over.
The second systemic angle is the PG Lang trademark architecture and the corporate structure that Dave Free has been quietly building on the operational side, and this is where the story connects to something much bigger than one lawsuit. When Kendrick Lamar and Dave Free walked PG Lang through its trademark filings across the streaming, apparel, film, and beverage categories over the last several years, they did it in a very specific sequence with a very specific legal architecture. When they launched Project 3 Agency in July 2025 as a full-service global creative firm operating under the PG Lang umbrella, they did it with a structure that separated ownership across categories, stacked intellectual property across multiple entities, and built a licensing architecture so that no single upstream partner has full leverage. That architecture is completely consistent with a legal team preparing for future litigation with a major label, because when you build a fully vertically integrated media platform, you are eventually going to end up in a legal fight with the entity that used to control your distribution. That is not a hypothetical. That is the actuarial reality of every independent creative company that has ever scaled past a certain revenue threshold. Every one, no exceptions. So imagine, 6 months from now, or a year from now, Kendrick Lamar's team ends up in a contract dispute with Universal Music Group over the terms of a future release, a future artist signing, or a future catalog acquisition. Imagine that in the middle of that dispute, Kendrick Lamar's counsel walks into a courtroom, files a motion, and cites the exact sentence Drake's attorneys wrote in the defamation case, the sentence where Drake's own lawyers formally acknowledged that UMG runs coordinated corporate promotional campaigns on behalf of specific artists with specific infrastructure. That is not hypothetical. That is a citation. That is a fact. That is admissible evidence. And that is exactly the kind of foundational leverage that turns a routine contract dispute into a negotiation Universal literally cannot afford to lose. Because the moment that admission enters a second filing, it becomes precedent, it becomes leverage, it becomes an anchor that Kendrick Lamar can drag Universal's entire legal posture behind for the rest of the decade. Kendrick Lamar has been playing a completely different game than Drake for 18 months, and the game he has been playing is a game where every move is a legal move, every filing is a piece of infrastructure, and every trademark is a piece of a wall. Drake has been playing a game where every move is a headline. That is why one side is building an empire, and the other side is defending a shrinking territory.
The third systemic angle is the ripple effect across the entire Universal Music Group roster, and this is the one that makes this filing a structural earthquake rather than just a personal embarrassment. When Drake's attorneys formally acknowledged in a federal filing that UMG runs coordinated corporate promotional campaigns on behalf of specific artists, they did not just create leverage for Kendrick Lamar, they created leverage for every artist currently on the Universal Music Group roster who is watching this play out. Every artist inside Universal's ecosystem now has a documented, on-the-record admission from a peer's own attorneys that Universal deploys coordinated corporate promotional campaigns on behalf of specific rostered artists. That admission is going to get quoted in future contract negotiations. That admission is going to get raised in future artist meetings. That admission is going to sit inside every future disagreement between an artist and the label as a permanent piece of leverage that did not exist before this filing was drafted. And this connects to something that the industry has been dealing with for years, the historical pattern of legal filings creating permanent evidentiary trails that reshape the balance of power long after the original case is resolved. When Death Row Records filed for Chapter 11 bankruptcy protection in 2006, with Suge Knight claiming debts exceeding $100 million, the filings inside that case created a permanent evidentiary trail that competing labels used to structure their own artist contracts more favorably for years afterward. When Cash Money Records went through its accounting disputes, the discovery process created a similar evidentiary trail that other labels quietly quoted back in their own negotiations. Legal filings inside this industry are not one-time events. They are permanent additions to a shared evidentiary library, and every party with a competent legal team knows how to check that library for citations. Drake's counsel just walked into the biggest legal library on the planet and dropped a book on the shelf that Kendrick Lamar's team is going to check out and read for the next 10 years. And so is every other artist with a competent lawyer who understands what just happened. Drake did not just hurt himself. Drake handed a rhetorical weapon to every artist inside Universal's system who has ever wanted to renegotiate a contract, restructure an arrangement, or exit an agreement. Every one of them just got stronger because Drake's lawyers wrote the wrong sentence on the wrong page. And here is where I need to mark my speculation clearly, because I'm not going to pretend a filing has been made public that has not been made public. I have not seen a proactive Kendrick Lamar filing on the docket yet. What I am telling you is that there is a scenario, and it is not a fringe scenario, in which Kendrick Lamar's legal team is currently drafting exactly that kind of proactive filing right now, designed to lock in the specific admissions from the Drake versus K
Universal record before those admissions can be sealed, redacted, or otherwise buried through subsequent legal maneuvering. That kind of proactive filing is precisely what you do when you have identified a golden citation inside an opposing party's record and you want to make sure it stays discoverable in perpetuity. And if that draft does not already exist in somebody's cabinet at PG Lang's outside counsel, I will bet real money it exists within 30 days, because that is what a competent legal team does when a gift like this drops into their inbox. I have been saying this for a long time, and now the evidence is catching up to the analysis. The best legal strategy in corporate litigation is often the move you do not make. You sit still. You let your opponent build the record. You let them characterize the infrastructure. You let them describe the promotional campaign in their own words, under the standard of a filed pleading, and then you file that characterization away for the day you need it. Kendrick Lamar's team has been doing exactly that for 18 months, and the dismissal in October 2025 did not end that strategy. It accelerated it, because the dismissal made the admissions permanent. The case is closed, the record is sealed in amber, and the admissions are never going away. Now here is the truth bomb, and this is the moment where everything I have been building comes together, because what I am about to tell you is the single most important thing about this entire story, and it is the thing that almost nobody is talking about. The real damage of Drake's lawsuit against Universal Music Group was never about whether he won or lost the defamation claim. The real damage was never about whether Judge Vargas ruled correctly or whether the Second Circuit overturns her on appeal.
The real damage is not even about the specific lyrics of Not Like Us, or the 5 Grammys, or the 13.3 million Super Bowl viewers, or the 1.8 billion Spotify streams. The real damage, the catastrophic, irreversible, career-defining damage, is that Drake's own legal team, in an attempt to protect his short-term reputation, permanently mortgaged his long-term structural leverage inside the most powerful label system in the music industry. They did this by formally acknowledging, in a federal court filing, under the standard of a filed pleading, that Universal Music Group operates coordinated promotional infrastructure that it deploys on behalf of specific artists. That acknowledgement is now a permanent feature of the public legal record. It is discoverable, it is citable, it is admissible. And it benefits the one person in this entire saga who never filed a single motion, never said a single word in court, and never spent a single dollar on legal fees to obtain it. Kendrick Lamar just received, free of charge, the most powerful piece of legal leverage in modern music industry history, delivered to him by the legal team of the man he is at war with. That is not a spin, that is not a reach, that is a documented, on-the-record, permanent evidentiary asset that Kendrick Lamar's team can now cite in every future dispute, every future negotiation, every future arbitration involving Universal Music Group for the next decade. And there is no version of this story where that citation does not eventually surface in a filing that restructures contracts, rewrites the balance of power, and potentially end careers. Think about what is being shown to you versus what is being told to you. What you are being told is that Drake lost the defamation case and is appealing. What is being shown to you is that Drake's legal team built a permanent monument to a set of admissions that the opposing side of a corporate rivalry can now use as a foundational legal weapon for the rest of the decade. Those are two completely different stories, and only one of them is the real one. The real one is the paperwork. The real one is the record. The real one is the sentence on the page that Drake's own attorneys wrote, stamped, and delivered to the public docket of the Southern District of New York. And when this rivalry is written up in music business textbooks a decade from now, the chapter will not be titled Not Like Us. It will not be titled Meet the Grams. It will not be titled with any song. The chapter will be titled with a case citation. It will be titled with a docket number. And the lesson at the bottom of the page will be the same lesson that lawyers have been quietly repeating to their clients since the beginning of American corporate history. Never put anything in a filing that you would not want your opponent to quote back to you a decade later. Drake's team broke that rule. Kendrick's team is going to enforce it, and the consequences of that are going to ripple through the music industry long after the memes have died and the timelines have moved on to the next spectacle.